Yes, good evening to the participants of the SLW-600. Welcome to my class, Karbusan in Kiswahili. And I think I posted something on the screen. I don't know whether you could be able to see it or not. Could you be able to read it? If it is able to read it, please read.
Purposive approach is a modern version of the mischief rule. It is certainly more flexible than either the literal rule or the golden rule, which tend to concentrate upon the meaning of individual words or phrases. This rule allows a judge to add or ignore words in the act to help them give a decision that supports, in their view, why the act was created.
Thank you very much. The purposive approach, I will give a little, then I will give the chance to you. The purposive approach is a modern version of the mischief rule. It is certainly more flexible than either the literal rule or the golden rule, which tend to concentrate upon the meaning of individual words or phrases. This rule allows a judge either to add or ignore or remove or delete words in an act to help them give a decision that supports, in their view, why the act was created. What is the purpose of the act which is created over there at the time? So, a full discretion is given to the judge to overlook the literary rule meaning and the golden rule as well as the mischievous rule, its reflections, and he can also deviate it. Why? Because he wants to give the justice to the party, number one. Number two, what idea the parliamentarian use such a word. That is the important factor. So, today that I had told you, either online or offline, who is going to present the purposive rule? Yes, either online or offline. Anyone can come forward. Yes, you can present. Physically, he is present here. Okay, you present. What is the purposive rule? Say loudly.
Purpose rule is the approach of the judge to interpret the purpose of enamoring.
Are you hearing me? Could you hear the sound of the physical person, those who are presenting it? Say yes.
No.
You are no. Say loudly. Imbele.
Purposive approach is the way of interpreting the statute by the judge in order to give the purpose in which the statute was, which the statute the parliament is intended to legislate.
Now are you hearing him?
A little bit.
Say loudly.
Purposive approach is interpretation of statute by a judge, in which a judge looks at a purpose in which a statute the parliament intends to create, so as to do justice and to get what the ideas of the parliament on making such a law or statute.
Good. Can you, what is the citation? A case law? Did you see the case law? Did you study the case law? No, the idea is very good because the aim is to update the intention of the parliament with the prevailing circumstances. The purposive approach is a new invention in the rule of the statutory interpretation, and it is commonly used as the European Union or any other person also now you are using it. The purposive approach to statutory interpretation have a different phenomena. Like the purposive approach to statutory interpretation is used to the European Court of Justice. The literal rule would be of little use in the European courts since there are several languages in operation and translation is not an exact science. Domestic judges are required to apply the purposive approach whenever they are applying the piece of EU law. Here the Lord Simon explained the purposive approach in Mounsell versus Olin's case law. And the case summary is like this. The first task of the Court of Construction is to put itself in the shoe of the draftsman. The purpose of making it, first and foremost, you have to step your shoe of a draftsman who drafted the legislation. Then only you will understand what is the intention of him. So, to consider what knowledge he had and importantly, what statutory objective he had at the time when he enacted the enactment. And he had been thus placed, the court proceeds to ascertain the meaning of the statutory language. In what context that he used the particular word. And that will be known it. That's why the people say, how could you love her? And how did you marry that girl? She is as black as charcoal. He is more black than the Sudanese. But still you loved her, you married her. Do you know what this fellow says? You look through my eyes. You know the beauty in her. Is it clear?
Yes.
In the same way, here the judge told, you look in the angle of a person who drafted it, means parliamentary. Then you know what exactly the meaning of it and why he did so. And moreover, a man who carries the load on the shoulders only know how much the weight it is. Not that man who is looking at you. So the same purposive approach also they have in the same. Thus the purposive approach to statutory interpretation seeks to look for the purpose of the legislation before interpreting the word. Before you are interpreting the word, first you see what is the purpose of making such a word by the legislator at that time. So that's why I say, step into the shoe of a legislator, then you know the real meaning of it. It has often been said that the purposive approach is a mixture of domestic rules. However, whereas the domestic rules require the courts to apply the literal rule, and they could apply sometimes the golden rule, and they can skip the mischief rule, and they will come to the purposive rule. That means he can choose any from small amounts, or he can deviate it, or he can make some twist, and he said that is the purpose of a legislature or a member of parliament, and that's why they enacted the law and used a particular word. So that is they say, however, the approach is mixture of the domestic rules, and whereas the domestic rules require the court to apply the literary rule to look at the wording of the act, and if the literary rule fails, at that time you deviate it and apply the golden rule. Even a golden rule also sometimes fails over there, you can apply the mischief rule, and if the mischief rule, a little change or a new version of the mischief rule is purposive approach or purposive rule. So the purposive approach starts with the mischief rule in the seeking the purpose or intention of the parliamentarian. It is therefore as much flexible approach giving judges greater scope to develop the law in the line with what they pursue to be the parliament intention. So here a judges play a major role to see that what is the intention of the parliamentarian. So a judge will step into the shoe of a parliamentarian to see why he uses such a word when he is making the law. What is the purpose of it? So he will interpret it. The purposive approach more readily embraces the use of the extrinsic aid to assist in the finding of the parliament intention. See, sometimes we cannot make it out clearly how we can use what is the intention of the parliamentarian by using such a word. And so what is that reason what you do? Suppose if you want to know a particular person character, because somebody is going to give the girl to her to know his character, conduct. What do?
Refer his background
Where do you go?
to the society or to his parents.
Even the police station also.
Yes.
To see whether he is having any criminal record or not. Plus, suppose if he studied in a particular area, south, and he will come and ask the dean how he is. He is a very good or intelligent or just, and he will take the opinion of the a dean also. Then he will go to your native place and search there how his behavior would be there. And he will go to the society, he will go to the place where you are working, and they find it out. But it will not be known to you. They will get the information from the other sources. And they will go to a family doctor also, whether he is having the AIDS or something. Because he'll say, sir, I am going to give my daughter to the so-and-so person. Please tell me, sir, it's a question of my daughter's life. At that instance, the doctor definitely revealed the truth. Because professional ethics says, in such a thing, yes, you can reveal it. But you cannot stand on the roadside to canvass, so-and-so X is having the positive, AIDS positive, HIV positive. What is the purpose of making? No, I want to see that nobody should have to make it. Why you want to worry about it? The person who wants to give the daughter, he will take the care of it. You are not supposed to give the secret. That is against the ethics. Is it clear?
Yes.
Online people, now let us see that. They want to know the extrinsic aids and intrinsic aids. These are the tools to find out. I don't know how many, because, sir, we did not know what we ate yesterday morning, and you are asking such a question which is some 2 years or 3 years back. Online or offline, can you give me what is the extrinsic aids, what is intrinsic aids, or external aids or internal aids? Anyone? The self-explanatory it is. In that extrinsic aid and intrinsic aid is given in the explanation there itself only. External aids mean not from the statute, from other sources. But the internal aids means from the statute. In the statute, you might have seen it. Short title is there, long title is there, and side margin is there, left and the right hand margin is there, marginal notes. Did you see it?
Yes.
Plus provision is there, main section is there, then subsection is there, then proviso is there, then clause is there, then illustration is there, then example is there. Are you following me?
Yes.
Where do you find them all?
In the status.
It is called
Internal.
internal aids. External aids are those aids which from the other sources, like what Professor Shivji is told about legal system, what Chris Peter Miner told, what Fimbo told, and what Luga Kingira has given the judgment in a particular case law, what Maula Sinya has given the judgment in particular case law, what Ramadani gave the judgment in the so-and-so case law, what the Court of Appeal opinion, what the East African Court of Appeal opinion, what the International Court will say about it, what the dictionary say about it, Black's Dictionary, what the encyclopedia say about this. and what the Hansard say about it. Najwa Hansard. What are they? It is the debate and discussion of the parliament is called Hansard. Even that also the external aids. I told you, no, I delivered here so many lectures on the interpretation of the statutes. You can check in my YouTube. So many lectures. Roughly, I can say 30 to 40 lectures in the interpretation of statutes. It is the same, either you teach in Tanzania, either you teach in India. But the only thing is, we take from the statute from here and we take the statute from there. But the same internal aids and external aids. No change at all. But we'll say parliamentary debates there, and here we'll say Hansard. In India, we don't say parliament Hansard. No, we say parliamentary debates. But here we'll say Hansard. That is only the difference. So, when a case law is silent over there, they go for a purposive approach, and the parliament intention relaxing the rule in the reference to the Hansard. Hansard means parliamentary debates. And Pepper versus Hart case law. House of Lords adapted the purposive approach. In the Pepper versus Hart, they refer the Hansard why a particular word or meaning is taken and applied. The courts are required to apply the purposive approach when interpreting the EU, that is the European Union law. The courts have used when interpreting the domestic legislation to give an interpretation in line with the EU law. Domestic legislation plus international. Both together will go, and what meaning that will get it, we will make it out. Here, it is not clearly given actually what is the thing it is given, not clearly mentioned. But I can give an example what clearly mentioned or not mentioned. For instance, any day in one day, a shop should be closed. Is it clear?
Yes.
Why? Why? According to the labor laws are concerned, or Shopping and Merchants Act is concerned, or any act is concerned. The reason is, ILO says, legal instrument says, you have to give the worker one day holiday. You have to give the worker one day holiday. But in production side, they cannot give the holiday because production will be stopped. So, shift system is there. And they will say, if a person works in a one day extra, he will give one day payment and one day leave. You will entitle for one day leave and one day payment extra. Yes, they will give such a bonus because it will stop. So, in shop, you are supposed to close one day. Is it clear?
Yes.
Good. And a shop, the inspector is there. Generally, who will check it, labor inspector, labor officer, or somebody would be there, will check it. And that fellow is kept it open on Sunday. Let you presume all the days, Sunday is a holiday. Let you presume it. So, Sunday he kept it open. He asked me, why did you keep it open? Sir, this is my house and this is my shop. How could I go out when I close the shop? So, I did not keep any employee here. I myself is here. If I may not go to the market, my wife is here. If my wife goes to the bathroom, my daughter is here. If my daughter is go for the chakula, my son is here. But no employee. So, he filed a case against that. You are supposed to close the shop on Sunday. You did not close it. But he said, if he is an employee employed over there, then I have to close the shop. But I did not employ the employee on the day. Myself is taking care of it. And the court has given the interpretation by looking that statute which is made. The long title of the statute says, this one day holiday would be given to protect the health of a person so that he could lead a happy life with the family and other things. That long title says. for the keeping the health of it, one day holiday should be given. Either you yourself did it or your employee did it, doesn't matter. A holiday should be given. Which day holiday depends upon the country to country. For instance, you go to the Saudi Arabia, holiday is on Friday and Saturday. But earlier, holiday was Thursday and Friday. But now they changed it. It is holiday in Friday and Saturday. Sunday is a working day. What about here? Saturday, Sunday is the holiday. I don't know whether some banks know they work on the holidays and they close on the working day. Did you see it? No, there would be certain banks are there. They work on holidays and they close on the working days because to facilitate the people, those who are holidays, to come and make the transactions. So with that view, they will open it. Some branches, not all the branches, some branches on the demand of the people, those who are the holders, account holders. Yes, so that is the thing which is, I give the example, but he has not clearly mentioned here. And one should have to reach to the Hansard. Hansard says, this is the so-and-so thing. But you can use of any one of the case law. And of course, let me see whether he has given. The purpose of the approach has been highly influential and judges have applied in the interpreting the domestic legislation which has no connection with the EU law. And no, here the case summary he said, but he did not give it. So advantage of the purposive approach and another purposive approach I can show you. See, the bitten with the teeth, that case law we referred. Either not necessarily instrument can be used for the wound, instrument can be used for the stabbing. No, we should not supposed to use the literary rule. Even the teeth also becomes your instrument. And hence, you will be held liable to pay the compensation. So deviate from that rule. Purposive rule could be applied. And greasing the line. Again, I told you, greasing the line. Purposive rule should be applied. And standing on the road, on the street. We are not standing on the street. Smith versus Hutch case law. We are not standing on the road. We are standing in your balcony. Either you stand there or you stand on the road, but you are doing the same thing.
Yes.
What? Luring the customers. Yes, Mishmiwa, your house sound, I could see you. I could hear you. Okay, now, advantage of a purpose. You can use all those cases also. You can write in your exam. Yes, a purposive rule should be over. Hence, it is failed to give it. You can write the purposive rule. Yes. All this literary rule example, the case law, and all three cases you can cite it. Even the second marriage case law. Second marriage case law also there. Yes, you can cite it. It is there in my handout. All these cases are there in my handout. Yeah. Only one case is enough. But if you mention the local case, Zuri Sana. Yeah. So, advantage of the purposive approach is it is a flexible approach which allows the judges to develop the line with the parliament intention. Yes, what is the intention of the parliament would be there, and that is it will be made clear, and it allows the judges to cope with the situation unforeseen by the parliament. Even the unforeseen situation also we can make it out. It allows the law to develop or cover the advantage of the medical sciences. Yes. You know, earlier, you cannot give the evidence through the internet or online or by the conference. Because of the pandemic, what they did? You can make an argument also online. You can give the evidence from America also online. You can give the evidence of the medical expert from the American a hospital also for the online. Now it is allowed. See, law changes depending on the change in the society. So hence we can say law is an instrument for the social change. Is it not?
Yes.
And law is a tool for the society to make run in a smooth way. So everybody gave the own type of the law. A law is a purposive one. A law should be a united one. A law should be a maximum people get the benefit out of it. Are you following me?
Yes.
So that is the purposive approach, and that is called pragmatic approach also. Means practical. Yes, here reference to the Hansard makes the easier for the court to discover the parliament intention in the Pepper versus Hard. And actually I read this case law, but I did not know. It says about something there. I read it, but I don't know. I've forgotten. Some word is, the clarity is there in the Hansard. The word clarity is there in the Hansard. From there he has taken, hence it is held liable, they said. But here it is not given, but it's supposed to give. Judges are given too much power to help the law. Of course, disadvantage he is showing. Judges are given too much power to develop the law and usurping the power of the parliament. And judges become the lawmakers, infringing the separation of the powers, Montesquieu theory. And there is a scope for the judicial bias in deciding the parliament intended. There is a biasness should be there, disadvantage. It assumes the parliament has one intention and ignores the fact that the parliament is divided into the party lines. Means parliament gives one intention and this judge will give the different intention. And he say, is the intention of the parliament. Allowing the reference to Hansard may lead to the prolonged examination of the relevant material by the lawyers, which add to the cost by the length of the litigation. So Hansard is not, you should not use there because it covers the many things. And the purpose of the approach to statutory interpretation, yes. Tanzania law is Joseph Arioba versus Stephen Wasira and others. Either you do a corruption activity or you do illegal activity. Both, it's the same result. Not only that. So bribery is not illegal? No. Even a takrima is illegal now. A gift is also illegal. So a mischief rule could be used over there. And R versus judge of the City of London court also used the same. That is, they lead to the manifested absurdity. The court has nothing to do with the question of whether the legislation has committed the absurdity or not. Greasing. No, he's actually greasing comes under the maintenance. What comes under maintenance in the house? Everything a house needs come under the maintenance. Is it or not? Even a motorbike. Do you have the motorbike or you have a picky? You have the motor four-wheeler. So in the four-wheeler, maintenance should be needed. What is maintenance? Repair maintenance, fuel maintenance. Suppose engine oil maintenance. Suppose bumper came out, you have to fix the bumper, maintenance. Suppose Indani harafu, the zuri harafu, the smell, it is also maintenance. And you will keep the, even for wash our hands, a soap, something like liquid soap, and a perfume, and napkins. Are you following me?
Yes.
It is all under, and you can keep some maji, kula, and a kunwa maji, maintenance. Cleaning. So, maintenance, everything will come under the maintenance. Only repair is the maintenance? Answer is no, they say. And we have a case law, I don't know whether you read the case law or not. Overhauling, you know. His motorbike is there and he made the overhaul in the Monza. He's a mechanic. And when you overhaul, when the engine down, you make it piston, especially two-wheeler. When you make the piston down, and everything should be changed. Even the packages, you know packages? Otherwise there is a leak. And the engine oil should be changed. When you once open the piston. So, sir, you did not say, the mechanic said, sir, the owner said, mechanic, you did not say this. No, overhauling charges means these are all the extra charges automatically comes over there. When once your engine opens, piston opens, all the charges will come. So that are overhauling charges. And where everything will come. It is implied. Is it clear?
Yes.
So, the implied meaning would be there. So, naturally one should have to bear it. And this is another, yes, a court of law, the court appealed there. Then, yes, these are the things. Yes, one of the case law also is mentioned, that is Kim means Ballroom Company Limited versus Zenith Investments Turquoise Limited. That is a case law, House of Lords, that the Lord Diplock has adapted a what was described as the purposive approach instead of a literal approach, and imputed to the Parliament an intention to impose the prohibition inconsistent with the object which statute was designed to achieve, though the draftsman had omitted to incorporate the express words by reference to the intention. Of course, they say they can create sometimes, not they missed, not, N-O-T, not. But if you read the total sentence, you know it. Not is missed, actually it is a negative sense. So even a letter also missed, yes, the sense is very much clear. That sense can be used over there. And the literary ure we can abscond, yes, we can divide it. And golden rule also we can deviate it. And then mischief rules, yes, refined version of the mischief rule is purposive rule. It is a refined version of the mischief rule is called purposive rule. Yeah, purposive. The court hence arrived at a conclusion that the consistent with such a holding, the court declined to adopt the literal approach instead of read with words in the provision of the statute which he was construing. So whenever you construed, especially tax law, you should be very much strict. Whenever you construe the penal law, you should be very much strict. I wrote the 2 articles on the interpretation of the statutes, and it was published by the Bar Council of India. It's the prime body which regulates the regulatory body of the LLB, even a regulatory body of the LLM, and practicing lawyers body also, disciplinary committee is there, legal education committee, what courses should be mentioned, what are the core courses, what are the, yes, such a body, they publish the journal. So I published this article in the journal. I don't think that is available in the net or not, but I gave in the University of Dar es Salaam that article hard copy. If I find it now, I can circulate to you in your email, because it might be somewhere in my data. So that is a strict construction should be given over there. The tax statutes are concerned and the penal statutes are concerned. And now let us come to the legal reasoning is concerned. The reasoning and interpretation, both are interwoven. No logic, no reasoning. No reasoning, no law. No law, no logic. Reasoning is logic, logic is reasoning. And reasoning is law, law is reasoning. And law is a logic, logic is a law. Interwoven. So legal reasoning is the process of devising, reflecting on, or giving a reason for the legal acts and the decisions or the justification for speculative opinions about the meaning of law and its relevance to action. A reasoning would be given over there. I gave one of the example. Where do you spit and how do you spit? Reasoning, a logic. Where do you spit and how do you spit? Show me. To the left or to the right? Online people, on the day I have shown you by opening my video. I have shown you on the opening my video. Could you see Matanashati?
Yes, Mtanashati, yes.
Yes. I told you on that day, how do you spit? I say bend down to the left and you spit so that the spit particles will not go back, number one. Number two, that is the purpose, because anyone wants to overtake you, he cannot overtake you from the left, he should overtake you from the right. Is the Constitution says or Criminal Procedure Code says? Who says?
More
Who says? Moral says,
Has,
reasoning says, logic says. It is a reasoning and logic says like that. Is it clear?
Yes.
yes.
So, reasoning and logic and law, how it could come. And I already told also that reasoning, logic, and law and justice, equality or equity. Which one is the best one? I gave the reason. The first son, second daughter, and third daughter, and fourth son. And they are very big officers. I gave the example. The first day. So sometimes you should not use the law. No, you should not use the law. You should do the reasoning, and reasoning plus justice. You have to look at it. Both the things. So, and here they say, many authors say relevance of action and meaning of law is more important factor. Of course, many profounders are there here. Alice Arino, Robert Alexi, Manuel Attenja. But many people propounded the view that legal reasoning is a particular instance of general practical reasoning. It is a practical thinking, practical doing is called a legal reasoning. They suppose that is to say that reasoning can link up with the action, guiding one what to do or what not to do, or showing whether or not there are good reason for a proposed course for action for something already done. So a logic is there, a reasoning is there. And when you are in bathroom, you are undressed. But when you come out, could you come out in the same way?
No.
Even the people are there, people are not there. Your own wife is there, own wife is not there. A reason is there, you come with the towel. Sir, can I come with the towel? Can I wrap down portion or up portion? If the ladies are there, kati, like a kanga. If the gents are there, lower portion. Reasoning. Are you following me?
Yes.
Yes, Professor.
So the reasoning is very much important factor to do a particular thing or not to do a particular thing. And they suppose that also the law reasons link up a legal decision in this way. So reason goes with the law goes with the reason, and the decision will come out. Both suppositions are well founded. Law regulates what to do and how to respond and what has been done or doing. So within an institutional framework of legislatures, law courts, enforcement agencies, and the like. So law says in one way, what is the punishment? But law also says how a punishment could be executed. That is a procedure. So it is a future of legal institutions. They are expected to have and usually to give a good reason for what they do and to do this in a public. So legal reasoning is therefore not only a special case of practical reasoning, but especially a public one, which is for the public good. So rationality in action has at least two requirements. What is the rationality? What is the two requirements for this one? Number one, the first is attention to facts. Give the attention to the facts, to the true state of affairs in relation to which one acts. Means give an importance to the facts, number one. Number two, attention to the reason for action relevant to the facts ascertained. So what would be that facts attention and what would be the reaction? Attention to reason for action relevant to the facts ascertained. What action could be relevant for facts ascertained? That is the second point. First, you ascertain the facts. Based on the facts, what action should be taken is the reasoning. And that is the second one. Attention to the reason for action relevant to the facts ascertained. Whatever the fact ascertained, which action is relevant to ascertain or to do to come to the justice. The former aspect of concerning is reasoning about the evidence, the later reasoning about the rules. Asserting the facts are evidence, and asserting the rules are called here. The former aspect of concerning the reasoning about the evidence, the later reasoning about the rules and norms as a reason for action. What rules and what norms would be applied for the facts means nothing but application of law to the facts. Is it clear?
Yes.
But how they applied? By some kind of deductive reasoning or non-deductively. So the reasoning, maybe the deductive method is there, inductive method is there. Suppose if I ask you, what is your name?
Male. Male.
Spelling?
M-A-L-E.
M-A?
M-A-L-E.
Male.
Yes.
Male. Where do you stay? Where do you stay? Answer. Or where do you live?
Once.
At least he can say Mohanza. Because Mohanza knows to each and everybody. But Malimbe, not known to anybody. Suppose if I ask, where do you stay or where do you live in Malimbe? What the answer should be? You should not suppose to say Mohanza.
Yes.
Do you know?
Yes.
You are not supposed to say Mohanza. You should say Malimbe. Because I'm asking the question here, where? By staying in the Malimbe. At the time, you are not supposed to say Mohanza. Is it clear?
Yes.
So, deductive method means, and you are not supposed to say Tanzania. And you are not supposed to say East Africa. So I deducted. From where? I detected African continent, African continent to the East Africa to the Tanzania, Tanzania to the Mwanza to the Malimbe. What method I did it? I deductive method I applied it. Is it clear?
Yes.
Is the reasoning. Suppose if you go to the foreign country, say about you went to some conference to India. So somebody asked you, where you are from? Can you say, I am from Mwanza? Then what do you have to say?
Tanzania.
You have to say at least, sir, I am from Tanzania, which is in East Africa, in African continent. Is it clear or not?
Yes.
So, where the question is asked, how you have to give the logical reasoning. That is a very important factor. And don't say that I am from Malimbe. Toka wapi mirembene au kidango chakundu. They will say. Why this man saying mirembene? Why this man saying Malimbe? You should say the country. Or at least continent. Or at least the area. From there we can say, better if the country is good. Instead of Manza. So that is the answer. So, who says like this? Logic says. Deductive method says. Inductive method says. These are the methods you have to use it. And whenever you are going, suppose you want to ask where this dala is going. Please don't ask any time. Where this dala goes. Don't ask. Immediately other person says, where do you want to go? And he said, why I should have to tell? That fellow say, why I should tell where this dala goes? Your purposive approach is out. You have to use the purposive approach there. Your purpose is to go what? Where? Michlele. Is it Michlele? Uchlele. Uchlele. You want to go to the Uchlele. So in your Mijini, in the Mijini you say, whether this dala goes to Uchlele, that is the answer. Or whether this dala go to the south. Chuo. But never ask where this dala goes. Are you following?
Yes.
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 please ask the question also by using the logic. And that is the reason they say legal reasoning is therefore not only a special case of the practical reasoning, it is the inductive method. The deductive method, you will apply it. And what is the purpose of our asking the question also very important factor. And there is a saying, I don't know whether you believe it or not. I already told in the class. Don't ask a woman age and don't ask a man's salary. Because these are too sensitive. These are the two sensitive questions. So sensitive questions you are not sure. And you should not be asked whether you are a bikira. Because it is such a questions you are not supposed to ask. You can get it whether you are bikira or you are a matumba from the other sources. So the question purposive approach is there when you ask the questions. So the former aspect concerning the reasoning about the evidence, and later it is about the question of fact, and we will use the different techniques in know the reasons to get the answers, either the deductive method reasoning or the non-deductive method reasoning. Behind the rules of a law, there presumably lie other reason for having these rules. What kind of reasons are these? Developed though, what modes of the discourse? A discourse principles and perhaps, and how to a reason principle themselves, and a logical reasoning will come out. In logical reasoning, and you read syllogism, SYLLOGISM, syllogism. Of course, after 2 or 3 minutes, it will stop it. But meanwhile, syllogism means man is mortal. Means one will die. Man is mortal. Means one will die. Man will die. Socrates is a man. So Socrates is a mortal. See, I went to a big premises. I came to the small premises, then I came to the result. That is called syllogism. A big premises, what is that? Man is a mortal. You know what is mortal? What it means? Kufa. Is it clear?
Yes.
And Socrates is a man. You know Socrates?
Yes.
Who is he?
Philosopher.
How he died? Sir, we don't know. People have given the hemlock. Hemlock means poison to drink because he's a controversial man. His philosophy, nobody listen. But he's a straightforward man. Always straightforward man will not have the natural death. He will be killed. All the straightforward man will be killed. Don't be straightforward because after you are having only one maisha, better you try to give it. So here they said Socrates is a man. So Socrates is a mortal. So from big premise to the small premise, so small premise to the action. So you can apply it, but the same you cannot apply to the other people. See, Jimmy Carter is a citizen, and all citizen will be entitled for the president. Can all citizens be the presidents? Answer no. It is a negative syllogism. In negative syllogism, no. Positive syllogism will work for there. Because every citizen cannot become a president. Is it clear?
Yes.
So, syllogism is a positive syllogism and negative syllogism. And that way we have to adapt it when you apply the reason. Can you cut the branch by sitting this side and cutting that side? Answer is, you may fall. You may fall or not. No.
So I spend a lot of time working on social media for my clients. I create a lot of video content